Commissioners, welcome. Thank you for being here to the March 4th, 2026 meeting of the Clark County Charter Review Commission. Would you please join me in rising for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, Commissioners. Rebecca, would you please call the roll?
Chair, Adegwame,
Here.
Donnelly,
Here.
LeBrant,
Present.
Erickson,
Present.
Garber,
Here.
Hamlet,
Here.
Chrisley,
Here.
Landisberg,
Here.
Jay,
Here.
Klein,
Here.
Gasquet,
Here.
Holmgren,
Here.
Benton,
Here.
Haas,
Here.
and Silliman.
Thank you. We have a quorum. We'll now seek approval of the agenda. We have no proposed revisions. Is there a motion to approve the agenda?
I'll make a motion to approve the agenda. Garber.
Second, Commissioner Jay.
Okay, it's been moved and seconded to approve the agenda. Are there any opposed? Seeing none, our agenda is approved. Thank you. We'll now move to open public comment. Rebecca, do we have any?
We do have one person online. Caller, you've been sent a request to unmute yourself. Please do so. State your name for the record and go ahead with your comments.
Hello, my name is Bradley Branham, and I hope everybody's doing well tonight. I'm commenting on the proposed amendment 2611, prioritize public safety. I agree with the words and the spirit of the proposed amendment. However, I feel that it relies on an incomplete view of public safety. In a recent Columbian article, County Council Chair Marshall rightly points out that Clark County has a public defender problem. Recently, her concerns manifested itself in the release of 24 indigent accused offenders. Public safety requires both law enforcement and constitutionally mandated due process of law leading to the adjudication of justice. Without a public defender, this may not be possible. So I would like to urge Commissioner Silliman to maybe add a statement about public defenders in his consideration of public safety. Thank you very much, and thanks for all the work you guys are doing.
There's nobody else online.
Okay, thank you. That concludes our open public comment. We'll now go to executive committee reports. I want to provide an update on.
Chair, point of order. The next item on the agenda is the approval of the minutes.
I'm sorry. Yeah, thank you. Thank you, Commissioner. Yes, we'll go to approval of the minutes.
Landisberg, so moved.
There is one edit I would like to suggest. When we were taking votes on first readings, our bylaw or our work plan requires identification of 5 positive votes, affirmative votes to advance a first reading to become eligible for a second reading. I believe we were recording those just in the quantity of affirmative votes without recording names. And so we were not consistent with that. So I'd like to move that the minutes be amended to record the number of affirmative votes, and that in the instances where specific names were identified as being in favor of or opposed to amendments, that we simply revert to the number of affirmative votes. Commissioner Klein.
Thank you, Mr. Chair. In the new business first reading proposal amendments, 2601, I acknowledge that I did say that I wanted to endorse, or rather co-sponsor that amendment. Post-meeting, I did withdraw my sponsorship of that amendment, and I would like to go on the record to make sure that that stands corrected. And I told Commissioner Garber that I was withdrawing my support for her amendment.
Okay, thank you. So we have two proposed amendments to the minutes. Are there any other proposed amendments? Commissioner LeBrandt?
I'd like to suggest that at the very end of the minutes, Commissioner Haas has a slight typo in his.
Commissioner LeBrandt, can you speak into your microphone?
Toward the end of the minutes, Commissioner Haas has a slight typo in his name, and I'd like to suggest that we adjust that.
Sure does.
Thank you.
So
Commissioner Landisberg.
I just have a question about what Commissioner Klein said. So you changed your opinion after the end of the meeting, right? That's what you said. So I don't understand why we would change the minutes that we have.
Whether it's changed in the minutes or not, I am on record in this meeting stating that I've withdrawn my support for that amendment
Okay, that's
proposal.
fine.
So we can have that recorded in today's minutes, but for the purposes of the last meeting minutes that was said. So I believe it would be in order to keep that, but with the correction that you've now made it for this meeting. Commissioner Donnelly,
Yes, while we are,
can you speak into the microphone, please?
there is another typo directly after the typo involving Commissioner Haas in the word adjourn. And as we are correcting that, we might as well correct that one as well.
Thank you.
Thank you. Okay. Are there any other proposed revisions? Okay, so the revisions then are to correct two typographical errors and also to amend the vote recording to be consistent by acknowledging the number of affirmative votes numerically. Commissioner Alaguame.
Chair, motion to approve the minutes as amended.
Okay, thank you. Is there a second?
Commissioner LeBrandt, second.
Okay. Any opposed? Okay, seeing none, the minutes are approved as amended. Thank you. Okay, so now we will move to executive committee report. I have two things I'd like to start with, and we'll give some time to Commissioner Garber and Commissioner Haas. First, I want to let the body know that we will be exploring ways to further update the Charter Commission's website to increase visibility and transparency of our deliberation process by having the intake forms posted and allow for tracking of these amendments so that people can go to the website, see the forms, understand the progress from where we are now to where we go throughout the process, whether they continue or not. Right now, our intake forms are visible through the agenda, but we're looking to increase that by having exclusive space on the website dedicated to that process. Also, I wanted to receive a couple comments from the public who were asking about our status. I'd like to provide a brief update to the members of the public who may be following our work. As some context may be helpful as to where we have been, where we are now, and where we're headed with respect to our amendment proposals. This commission previously conducted a public concept disclosure roundtable where commissioners were publicly shared amendment interests. Those topics were recorded and posted on the commission's website. From that public discussion, commissioners were able to identify overlapping interests and complete an approved intake form summarizing amendment proposals and identifying other commissioners who had expressed similar interests by listing them as co-sponsors. Those complete intake forms are now being read into the record during what we are calling first readings. This step is intentionally broad and intended to surface ideas and determine which topics merit further consideration by the commission. In the coming weeks, proposals that pass the first reading stage will qualify for a second reading, where more detailed discussion and debate will occur. From there, some proposals that advance through second reading may become eligible for committee study where they will be examined in even greater detail. This is a deliberate winnowing process, and the commission has purposely begun by considering a broad range of ideas and will then narrow the field as proposals receive further review and discussion, and the proposals themselves are refined and clarified. Each step taken so far has been presented to and approved by the commission with the intent that our work proceeds in a clear and public manner consistent with applicable open public meeting requirements. As we continue to implement this process, the commission will also continue to look for opportunities to further improve clarity and transparency in how this process is carried out. Commissioner Garber, is there anything that you would like to share?
No, nothing to add. Thank
Okay,
you.
thank you. Commissioner Haas.
I have nothing for the commission.
Okay, thank you. Okay, we'll then move to comments by support staff. Start with Rebecca. Is there anything that you'd like to share with Rebecca?
No comments, thanks.
Okay, thank you. Okay, we'll next give some time to Katie, who will share with us some comments on a topic that was raised last meeting regarding our ethics and the extent to which they apply, the ethics in our bylaws and the extent to which they apply to voting on certain amendments.
Thank you. For the record, Katie Jolma, Civil Prosecuting Attorney's Office. I was not in attendance at the last meeting, so I was made aware via email from Chair Erickson about a question raised at the last meeting. I'm just going to summarize that rather than read the entire email from that, but during the February 25th meeting, a question was raised regarding whether the commission's bylaws apply to votes on amendments by commissioners who are candidates for other offices, particularly under the ethics provision. Okay, and I won't summarize everything else after that, but Chris Cook then, because she was the one in attendance, she responded just minutes before stepping into this meeting. So in her response, I will just read that out loud. That by her recollection, it was that the question was not related to the application of the commission's bylaws, but rather whether a commissioner should recuse himself or herself from participating on the proposed amendment regarding county council salaries if the commissioner is running in the election for a county council seat. I will address the general question because, as Katie's presentation at your first meeting made clear, there are a number of sources of ethics authorities, including provisions under RCW 4223070, which provides in part as follows. 1, no municipal officer may use his or her position to secure special privileges or exemptions for himself, herself, or others. She goes on to say that this statute supersedes any contrary provision in the commission's bylaws or in the charter itself, and that her view is that a proposal to increase the salary of a position for which a commissioner has filed as a candidate would be among the special privileges that are the topic of this statute. Consequently, the commissioner should recuse him or herself from participating in the commission's consideration of that proposal. The commissioner should not be in the room when it is discussed or voted on and should not vote on the matter. Best regards, Chris.
Thank you. I have one clarified question, then we'll go to some other questions. Her email didn't address, but perhaps you can. Can you comment on how that opinion applies to folks who have not yet but may announce a candidacy for the same office? If they were to vote and then later announce a candidacy for the office?
I think that becomes a factual analysis. but it would be my opinion to, as you guys will probably, you've probably noticed, we tend to err on the side of caution with these things. And in that vein, I would say that out of precaution, that if someone has knowledge personally that they are intending to file, and that could, and then they still participate in those discussions, knowing that this is the opinion that has been provided, the legal opinion that's been provided, that has an appearance of maybe some untowardness. And so I would suggest at this point, because again, this is a hypothetical and not a factual situation, that my advice would be to still recuse in the effort to shine the best light on this commission as a whole. And by the way, I was not here, so I'm saying this as broadly as it applies to everyone in this room, because anything that you touch on that has those special privileges, and it's the appearance of, it's not just that you are accepting them in reality, it's the appearance of those special privileges that it still applies. So that would be my suggestion right now.
Okay, the one final detail for me. So in the context of first readings, the votes that we take after a first reading is to seek the number of affirmative votes. We need 5 affirmative votes to advance a proposal to a second reading. There's no debate, although questions could be asked that are factually based, but there's no debate or discussion. And we're not voting yes or no, we're just asking for affirmative votes. In that sense, if someone chooses to not vote yes, which is the only form of participation in this sense, does the same recusal recommendations apply?
Thank you for that. I would, based on Chris's opinion that I just shared in her conclusion, in addition to the recusing of themselves from participating in the commission's consideration of that proposal, the commissioner should not be in the room when discussed or voted on, and should not vote on the matter. So when that particular proposal is raised, then I would ask that the commissioner in question politely recuse themselves out of the room in the hallway for the duration of that vote, and then is welcome to come back in after that.
Okay, thank you. And then for clarification, the amendment that is under consideration is with respect to the amendment that brought this question to light was with respect to county council. So is this opinion unique to this amendment with respect to county council? In other words, we're only talking about candidates for county council.
That was how it was proposed to legal, although having read through the proposals and the mandates for the Clark County Sheriff's Office to fund, it wasn't raised, but
well, my question is with respect to candidates, members of the commission who are candidates themselves. I think the topic on that amendment maybe is a separate topic, but that's the question under consideration right now is just asking for clarification about the extent to which that opinion applies to others who are seeking offices other than county council.
Well, I would need some more facts, I think, with regard to that. So I know that the proposal is raising the salary to treasurer, auditor as such. So, but those those are already funded as is and are publicized as such. Those salaries. So are you referring to if someone?
We have members of our commission who are considering and are seeking other offices behind county council. I just want to clarify that we're only talking about a very narrow topic, one amendment, and members of the commission are seeking a seat on the county council.
That's what this opinion was
Okay,
offered for.
thank you.
And so I will just say broadly, you all are aware, you all are good citizens, and that, again, it's the appearance of any ethical violations that if you feel that your current role or, you are taking steps to move into somewhere where it's going to create a conflict of interest or violate either the state laws or our ethics rules, to please do the, perhaps it's overly cautious, but I would say that, you should probably take in consideration all of those factors before voting and discussing and deliberating on these issues. And again, I don't have facts in front of me, but I will just kind of blanketly say that that's how we did the entire presentation so that everyone was aware, and that I would just caution that.
Okay, thank you. All right, I saw a hand up. Commissioner Klein, please.
Chair, I've done a lot of thinking about this since last meeting, and I think that there's a lot of presumptive leaps in this concept of conflict of interest, presuming that a person may file, that they may be elected, that the proposal may be adopted, that it gets through all the steps, that it will become an amendment proposed on the November ballot. Many presumptive leaps. I prepared a statement. May I read it, please?
Yes, if you could be efficient with it. Thank you.
I wish to address the comments raised last week concerning ethics and the suggested recusal of any charter commissioner who may be considering a future candidacy for county council, particularly with respect to charter amendments that could affect future compensation, future council compensation. While I share the commitment to the highest ethical standards, I must respectfully disagree that a conflict of interest exists under governing law. Charter review commissioners are subject to RCW Chapter 42.23, Code of Ethics for Municipal Officers, and Clark County Human Resources Policy 13.1, which applies expressly to elected officials, appointed committees, and advisory board members such as this commission. These authorities are designed to prevent actual self-dealing, not police remote, multi-step, hypothetical future benefits. HR 13.1 requires disclosure of any apparent or potential conflict or the appearance of a conflict between personal and official responsibilities. Once disclosed, the prosecuting attorney's office and human resources assess whether a conflict exists using four basic specific factors. 1, the degree of personal benefit to the official. 2, the benefit to a friend or relative. 3, the degree to which the decision or the action was or might be influenced by personal interest. And 4, whether the consideration was solicited. Remedies, if any, may include disqualification from the specific decision. None of these factors is satisfied here. Any conceivable personal benefit from a charter amendment on future council compensation is purely hypothetical. It would require A, a commissioner declaring and winning a council election, B, the amendment passing by voter approval, C, the change taking effect during the commissioner's hypothetical future term, and D, the commissioner's vote today being driven primarily by that remote possibility rather than the merits of the proposal. Such layered contingencies fall well outside the potential and might be influenced. Standard contemplated by HR Policy 13.1 and RCW 42.23.020 and .070, which target direct or indirect beneficial interests in current contracts, gratuities, or special privileges, not speculative future scenarios. Moreover, accepting the position that such remote hypotheticals constitute disqualifying conflicts would create a dangerous, slippery slope. A commissioner who might one day file an ethics complaint could be barred from voting on any charter amendment that reforms or strengthens ethics enforcement or whistleblower protection because they might personally benefit from more effective process. Similarly, any commissioner who might later seek county employment, contracts, or other benefits could be disqualified from deliberating on related charter changes. Extending the logic this far would effectively paralyze the commission, disqualify large numbers of qualified voter-elected members based on nothing more than speculation about what they might do years from now, and undermine the very purpose of a citizen charter review process. For these reasons, the concerns expressed go beyond the requirements of current RCW 42.23 and Clark County HR 13.1 standards. I reject any claim of conflict of interest in this matter and affirm that all duly elected commissioners may fully and fairly engage in our deliberations on their merits.
Commissioner Kwame.
Thank you, Chair. Based on the comments from legal, I just wanted to understand if we thought this might have ramifications for other amendments that may deal with council duties, or if there are other parts of the county's, or the charter's remit, I should say, where members of the commission are employed, or just really want to understand the guidance there.
Are you asking for guidance beyond voting on an amendment that related to compensation?
Yes, that's correct. Thank you.
Katie, do you want to make a comment, please?
Well, first, the question that was posed to us was that the wording was commissioners who are candidates for other offices, not. And so I am under the impression that there is at least one member here that is running for county council, correct?
That's correct. And to be complete, I've expanded the request for the opinion to extend it to potential future candidacy for the same office, just so that we have a complete discussion. I believe Commissioner Adegwame is asking for further expansion of the opinion to extend to guidance with respect to the council, not just with compensation, but to maybe other duties, roles, or responsibilities. Is that correct, Commissioner?
Yes, that's correct. I think hearing the special privileges part made me think there might be something there. So just want to understand the complete picture.
Okay. So to the extent that you're able to today, then we would be happy to receive that opinion. If you feel like you need more time, hear that next week.
In my understanding, it is the personal gain of privileges to oneself or to someone, a spouse or partner, a child, someone in your household. That is the typical extent of these applications. And so it is to gain personally in that way. So changing, in my view, changing the procedures of a position does not imply personal gain to that person. It would be for whomever is in that position. And it would apply once that person was not in, if they were in office and then they were not in office, it would still stand as long as the charter was written that way. So that doesn't, do you guys understand like where I'm getting the difference between personal gain and then what is procedurally done for the office that would apply to anyone in that office? That's where the rest of the rules say that, when I had said, if it applies to the county at large or to a department at large or to, all of these people who are in that same position, then that wouldn't normally imply a personal gain.
Okay, thank you. And in the interest of completeness, and then we'll try to move on, can you make any commentary on Commissioner Klein's statement?
No, I'm not going to debate our legal opinions.
Okay.
We have provided it And it is up to you whether you want to further debate, but I am not inclined to debate those legal opinions.
Yeah, I want to give the opportunity. Thank you. Okay.
Chair,
Commissioner Klein.
if I state today that I'm going to
Point of order,
run,
Chair, Commissioner LeGrand's hand was.
I'm sorry, I will come to you, Commissioner LeBrandt. I didn't see your hand up. Commissioner Klein, if you could finish your comment, then we'll go to Commissioner LeBrandt.
Commissioner Benton has announced he has not yet filed for the position. If I announce today that I'm going to run in 2027 for District 4 County Council, does it follow that I shall have to recuse myself from this vote? Remember, slippery slope, presumptive leaps.
I
So-
think your earlier comments, you didn't want to debate. So
So I am just giving the legal answer to that. So not debating, but in the state of Washington, when you announce a candidacy, you have to, the PDC, the Public Disclosure Commission, then becomes involved and reporting has to start. And so for that, I'm just stating that as that's a legal fact with regard. So it doesn't matter if it's before filing week or not. When you've made the announcement, then the state becomes involved in a legal way.
okay, thank you. Commissioner LeBrandt, please.
Yeah, I'd just like to throw out this idea before we, go down all the different legal and procedural permutations and really risk swallowing a camel and straining out the gnat, that we take a step back and think about the general public and what we, even just as members of the general public, would like to see from the folks in elected office. And that's not, can you or can you not get away with something legally? It's, does it or does it not pass the smell test? And just to make sure we calibrate that correctly, the easiest way to do that is to look across the aisle and say, if I saw someone across the proverbial aisle doing this, would I take issue with it? Would I have questions about it? I think far before we get to any of the legal minutia, we can start to think about kind of, does this pass the smell test? And that can save us a lot of time in terms of thinking about legal opinions or, all the various different scenarios. I think we can hold ourselves individually to maybe a higher ethical standard than what is specifically called out in various RCWs and WACs and everything else. So.
Thank you, Commissioner. Okay. Seeing that,
Can I make just one comment?
Commissioner Silwin.
Not to be too antagonistic, but just to be upfront, I'm going to announce that I am going to run for District 5 for the County Council with a friendly competition with my cohort here. I am also going to reject the reasoning of the prosecuting attorney's office. I don't see any direct benefit derived by a procedural vote allowing a proposal by a fellow commissioner to proceed to debate within the commission. There's hardly any direct benefit derived by that vote, and I don't see any reason to recuse myself from it. If for some reason that proposal got approved, all we as a commission are doing is approving that it be sent to the voters for approval. So again, there is no direct approval by my vote to a salary increase that I'm for an office that I may or may not occupy in a year. So I'm going to reject that reasoning. I think it's exaggerated. In fact, 15 years ago in the county council's office, I witnessed the county commissioners vote in a public meeting for their salary increases each year for a couple of years. That was not a conflict of interest. It was a decision made annually in an open public meeting. It's not something secret. There was no secret derived benefit from it. I do not believe it constitutes a conflict of interest. So, thank you, Mr. Chair.
Okay. Thank you. Commissioner Haas.
Chair, I think this is going to require a bunch of more discussion between the commission, and I would move that we add it to a new business item for an upcoming meeting, or we're going to probably be on this subject all night long.
Okay, thank you. Okay, We will move on in our agenda to the next item, which is to invite Judge Vanderwood to speak to us. Commissioners, you may recall that in our last meeting, we voted to invite elected officials to come and address us. And invitations were sent to the county council, our county manager, as well as the elected officials in the executive branch. We received responses from several, and they've been scheduled. Today we'll be hearing from Judge Vanderwood. Next week, we're scheduled to hear from Auditor Kinsey, and the week after that, we will be hearing from Sheriff Horch. In each of our meetings, we will allocate up to 15 minutes, which includes the comments by our invited guest, as well as question and answer. Rebecca will be putting a timer on the screen so we can be mindful of our time. That is not going to be enough time for each of us to ask a meaningful question and have a response. So as you are contemplating whether or not you want to ask a question, just be mindful of our time limits and the number of people here. So with that, Judge Vanderwood, thank you for being here, and we'll invite you to come and address the commission. Rebecca, do you have the timer ready?
Commission Chair Erickson, Commission members, I am Judge Vanderwood, presiding judge for Clark County Superior Court. I've been in that role now for a little over 5 years. It is certainly from the Superior Court, I wanted to express appreciation for you taking the opportunity to allow us to be here to provide information. I am providing a request on behalf of those 12 Superior Court judges in Clark County. They are all elected officials. The request that we are making is that you allow the voters of Clark County to decide whether the county clerk position should be an appointed position or not. The role of the clerk is certainly a critical one for Superior Court's operations and how things move forward. This is an important topic that is not necessarily new to this body for consideration. By way of brief background, recently, the county council considered whether or not to place a charter amendment for this purpose onto the November 2024 ballot. It was on the agenda for the council on a couple meetings in June of 2024. They had decided at that point that additional information and further discussion would be appropriate before any further decision was made. It was within that context then that in May of 2025, the Superior Court bench provided additional information to the county council stating our support for this proposal and requesting that the charter amendment be placed on the November ballot. The county council considered testimony in relation to that in July of 2025. They had decided at that point that it would be best considered by you as you take upon your work and effort in considering possible amendments. The reasons why we are supportive as a unified bench for this request are multifaceted. They include reasons and circumstances that have been evidenced and experienced over the years. They include areas such as an effort for increased efficiency, for efforts to improve cost savings, for increased and better service to the public. All of that service to the public is a critical component of what we do. When the public comes into the courthouse just across the street, they don't view the clerk's office somehow different than the judicial officers or court administration. It is in effect a single functioning system for them that they need to navigate and work their way through. A combination of having this system wherein the clerk is not an elected position, but instead a position that is designated and identified through the county, from our perspective, will allow that integration and that effort to be done more consistently, more effectively, in a way that's going to help the public. Some of the efficiencies and cost savings include even just examples. As the court system continues to grow with the increase in Clark County and the demand that is placed upon it, There are circumstances where, for example, additional judges need to be added to the bench. That happened a couple of years ago. When there's a judge added, there needs to be additional staffing that goes along with that. As the bench was making its request to the council to add an additional judge, there was a request to add a judicial assistant in connection with that. But because we don't have any control, input, direct involvement with the clerk's request, there is not a request that was formulated at the same time to have an increase in clerk staffing to go along with that. The clerk staffing position then became something that put on hold for an initial time. Our judicial assistant request, that was eventually approved. Just recently, the clerk received an added position for it. It's just one example about how the separation creates lack of coordination and inefficiency in a way that's detrimental. Shared cost and the savings for services are certainly going to be benefited from our view with this. And finally, a couple things I guess I'll note quickly. The model and pattern for this has been identified and established. It's even here amongst us in the district court model. The district courts throughout the state of Washington actually have not a separate clerk, but one within the clerk system. The reason why this can be set as a basis for a separate is because we are a home rule charter circumstance. Of the 7 home rule charter counties in Washington, 3 have adopted an approach along these lines, Pierce, King, and Whatcom. We think that it's appropriate for us to do so. So in closing, it is important from our point to make sure that this effort moves forward, to give the county voters an opportunity to analyze this and make a determination whether the change is appropriate for Clark County as we believe it is. Thank you. Any questions?
Thank you, Judge Vanderwood. We have approximately 9.5 minutes. Are there any questions that the commissioner would like to pose? Commissioner Chrisley.
Thank you, Mr. Chair. Thank you, Judge. But my question is, how would you see this being, how would you see hiring the clerk? Like, how would you see the process going through? Obviously, now it's elected by the county. How would you ensure that it's a wide dissemination, decision-making? There's not, either favor given for somebody versus somebody else.
It would be a process from our view in relation to a posting for a position as in other county positions as a important role and responsibility within the county, set specific backgrounds and capabilities and work experiences that that person has that then can be vetted, evaluated, and that decision process made. The alternative is the process which we have right at an elected standpoint, which you don't necessarily have someone who has any experience with the court system or any experience with operational issues as it relates to the courts. Now, there are some reasons why that can have other people outside of a knowledge base participate in it, but this is a very unique and focused position where we're talking about court operations and how that works. So hopefully that addresses your question. It's certainly in those models in relation that I talked about, Whatcom, King, and Pierce. They have listings that you can go onto their websites and see what they look like and how they've handled the process as they've selected those individuals.
Thank you. Commissioner Jay.
Thank you, Chair. Thank you, Judge Vanderwood, for coming to speak to us this evening. I just have a question if you would be able to articulate the reason why the clerk was intended to be elected as a member of the executive branch originally in the framing of our state constitutions. And
I think that would be a history lesson, the one I probably don't have the expertise nor the time to answer that, but I do know that it dates back to the territorial days in relation to Washington and the founding of the state and when the Constitution was originated. It does create the clerk as a basis. I would anticipate, although I can't guarantee this, that the role of the clerk and the function of the clerk and the courts and what it looked like then is much different than what we have now. The structures within the state are much different. The sizes of the county are much different. The type of work that the courts do now are much different. So I think that's probably a nuance. And there were probably more activities outside of the court system that the county clerk did back then than they do now. The role and function of the county clerks these days, I believe, is fundamentally based on the operational requirements of the court system.
Commissioner Klein.
Thank you, Chair. Thank you, Judge. In this election year, the county clerk is in the election cycle. And you're asking for an amendment to convert that to an appointed position. That doesn't line up. It would nullify the people's vote to elect the county clerk and then to take away their elected executive. So can you please tell me why we should do this amendment this year?
So I'm smiling a bit because that's something that we referenced to the council when we made the request last year to them to put it on last year's ballot. So
I was there.
it could be fully addressed before that. The fact that it is contemporaneous with this ballot, I think could be handled in a couple of different ways. One, I don't think that should be a reason to put off this important issue that allows this charter at certain time periods to allow the public to weigh in on it. But two, it could also be implemented in a 4-year phase, for example, so that it goes into effect after this current cycle. That would be one way to deal with it, I would think as well.
Thank you. Okay. Commissioner Silliman and then Commissioner LeBrant.
Thank you for coming, Judge. I believe I read the material, I think, that was presented to the county council, and a couple of things that were brought up in that documentation that were issues with the elected county clerk were what appears to be input errors. It was lawyers not being able to find the material because it was filed incorrectly in the system. And the other thing that came up was the clerk's filing system appears to be incompatible with the system you're using for actual court tracking. Is that accurate? And if it is, how does changing to a appointed clerk correct those two issues?
So I guess yes and no. It's complicated how the systems are set up, how they work, how they interact with each other. That's one reason why we feel this is a better position, if you will, not to have as an elected position, but take it outside of that area so that there can be more expertise moving forward in relation to who fills that function. As to your specific question, I will say that our request isn't based specifically on what's happening today with the clerk's office, yesterday's in the clerk's office. This is a bigger question. It's not a question for us that focuses even specifically on who the current clerk is or not. That's really, this request is independent of that. The question is what's better for the system as a whole. So some of those errors that are noted and identified in a system that can be incompatible, those can be functionality issues and what's involved with that. I think the clerk's position, if I understood what he submitted at the time, was that there's a challenge with retaining personnel and turnover that's related to it. We understand there's always going to be challenges with training and issues, but a properly functioning office for the clerk should be fully staffed. It should have a system to continue to train individuals, to minimize those errors, to have an auditing process to make sure it's functioning as effectively as possible. Those are all things that we think can be improved if there's better integration and collaboration between the system as a whole.
Thank you, Commissioner LeBrant.
Just wanted to say thank you for being here this evening and thank you for your service. You mentioned some efficiencies in cost and in time. Have you or anyone that you know of done any quantification around kind of what those could potentially look like?
Well, as far as the cost savings is concerned, we, as a Superior Court, we have very limited resources. We don't have much staffing with capability to take on those types of projects. There are some costs that we're aware of. For instance, the document management system that the clerk decided to move forward with, we feel does have costs to the county that are involved. I think the clerk's position is, because there's Another system that would not have those same cost with it, that's supported within the state system itself. I believe the clerk's position is, well, we have licenses that other people pay for to offset that cost to make it somewhat cost neutral. I guess my perspective would be we're still asking then members of our community to be paying for a service that doesn't necessarily have to be paid for. And as a court, we have to pay licenses for that as well. I think it's $24,000 a year, something around those lines. And district court, I think, has been paying about triple that, I believe. But so there are some of those costs, but then there's cost related to, I think, the synergy and working together on issues that would relate to savings. But I can't tell you that we have the capability to specifically quantify that at this point. Yeah.
Okay, thank you. We have time for one more quick question if anyone has not yet asked a question. Okay.
One other quick, I guess, cost savings that I'd point out that comes to my mind. Obviously, with the current arrangement, you have a set amount that the clerk as an elected office is getting paid. If it's not in that rubric, there's some potential cost savings directly from that, potentially as well, right? I don't know what that would look like.
Judge, thank you for being here. Appreciate your comments and being willing to field questions. Thank you.
No, thank you very much. Appreciate it. And we appreciate your work and effort, like I said.
Okay, thank you, commissioners. We'll move on. Our next agenda item is old business. First one is written correspondence from public. Commissioners, this is intended for us to have a conscious decision about how or if we want to, how we would respond to written correspondence. The commission has received several emails addressed to all of us from the public. And what we're hoping to have is a discussion about what our response, if any, would look like. For context, we do have open public comment when members of the public come here to speak with us. We don't have dialogue. We receive comment and there's no question and answer. That same argument could potentially be applied to written correspondence. But before we make a decision that we would or would not respond to emails that were sent to the whole commission, we'll have an opportunity for us to discuss that here quickly. So before we have a motion, what we'd like to do is just kind of go around rapid fire, just quickly, if you have some thoughts about whether or not we should respond or not, and if you do think that the commission should be responding to written emails, what you think that would look like. So if you don't have a comment, that's fine. We'll just go around the room and then we'll just kind of go in sequential order. Commissioner Alarguame.
Thank you, Chair. I think it should fall in the realm of public comment and open public comment as it does in many other boards and commissions. And it's meant to be comment that we take in mind as we continue to deliberate and vote, but I don't know that it needs a specific response.
Okay, thank you. Commissioner Donnelly.
Yes, my viewpoint would be that we should consider those emails good information, that we all read them and take them into account. But to place yet another burden upon any of us, especially our chair and our executive committee, I think we're within our rights to say no, that we're just going to thank people, or maybe even not even thank them, but use the information and not respond.
Thank you. Commissioner Gasquet.
Yeah, I'm of the mind that we treat written comment the same as public comment, separate from individuals reaching out to us, asking questions.
Okay, thank you. Commissioner Hamlick.
I'm in agreement with all of them. Exactly. You don't get comments when you come in public or on screen, so why do you get it in writing? So.
Okay, thank you. Commissioner Landsberg.
The only thing I would suggest, I wouldn't want to individually respond, but I know for a fact that several of these comments have to do with redistricting. And I would suggest that if we have a committee meeting, that committee consider inviting that person to come and make their own presentation.
Okay, thank you. Commissioner Chrisley.
I concur.
Okay, thank you. Commissioner Haas.
I think people like to know that they were heard. I would be in favor of a flat thank you very much for your input. We will share it with the commission in whole. And if you have additional points that you'd like to bring up, please come to an open public comment. But I wouldn't get into specifics about anything. That way, at least people know that they have been heard and the message didn't go to the spam or whatever.
Speaking for myself, I agree with everyone else, but I also agree with Commissioner Haas. I think some acknowledgement is appropriate, just so people don't wonder whether or not their comment made its way to its intended destination. Commissioner Garber.
Well, I totally agree with Commissioner Haas. I think that we need to at least acknowledge the person that we received it and let them know that we will be routing it to anybody. It's just as a matter of courtesy. But I agree that we shouldn't be spending time answering specific questions for them.
Thank you. Commissioner Sylvan.
Nothing different that hasn't been said.
Thank you. Commissioner Benton.
I have nothing to add.
Commissioner Jay.
I really appreciate what Commissioner Haas said in regards to having a formal response. I'd also be open to having individual commissioners at their own discretion respond to emails should they see fit. But aside from that.
Okay. Commissioner Klein.
So I totally adopt Commissioner Haas's comment, but procedurally, we have retention things. We have a retention policy that we have to be mindful of in our emails. What is the recommendation for setting those aside in response to, in consideration of the auto response? Each one of us, if we did a response, that would be a little over the top. If there was a way for an auto response to be generated from our email saying your message has been received, it will be shared with, if it was, if something appropriate like that, as opposed to us doing this multiple points of contact, I think that it would initiate too much back and forth with that citizen. And so I'd like to get some input on some of those. There was one email that was from a citizen who had a family concern, and this out of our scope, nothing we can do, and I don't want to delete it. I think it should be retained, just for the record, but tucked away somewhere. So I'd like to get some guidance on that.
Yeah, I think, for example, a designated member of the commission could act on Commissioner Haas's recommendation, and or we could have a member of the executive committee be responsible for simply acknowledging receipt on behalf of the commission. Commissioner Holmgren.
My only thought is that if we do treat these as public comment, does that mean that we should also be putting them in meeting agendas or minutes where we've acknowledged the name of the recipient, like we've done with people who call in for public comment?
So the emails are being posted, but we do have a meeting when we talked about enhancements to the commission's website, where emails of that nature will have higher visibility. So we've discussed amongst the executive committee and with staff that would suffice, that we wouldn't read each email into the record and consume meeting time doing so, provided that they're publicly visible on the website. Commissioner LeBrant.
Thank you for the great idea, Commissioner Haas. Some sort of auto response would be, I think, fantastic for the general public. Please don't delete anything from your email, even if it's not germane. And to echo Commissioner Jay's point, as long as we're not representing it as the commission as a whole, we're all welcome to respond individually. If there's something that pops out and you're like, hey, that's a good point, I need to, I feel strongly about that, go ahead and email folks back. Members of the public really appreciate that.
Yeah, the option existed before and will persist, that we have the ability and the right to be able to respond back to constituents. This discussion is with respect to whether or not we want to have a commission-wide response. So I think what I'm hearing is some consensus around a response acknowledging receipt and then leaving it at that. Commissioner Adegwemi, do you have one more comment?
Thank you, Chair. If I could just say, I know some boards and commissions will have one email address that's like a group email address where all public comment is received. And I particularly mention this because there was one comment I think we received, which I wasn't copied on due to a misspelling in my name. And so it's a lot easier for the general public if instead of having to copy 15 commissioners, there's one email address they can send their comments to. So we might want to designate one if we can't get the resource of another email account from the county. It might be worth looking at designating that all public comments are sent to a specific address.
Yeah, we do have that already, and that's posted on the commission's website.
Perfect. Then I think we just need to make sure that we make it clear for the public that that's the address for public comment.
Okay. Okay, so thank you for that discussion. Would like to ask for a motion just to formalize our discussion. Is there a motion to acknowledge that the response to public emails sent to the commission that will be acknowledged, but beyond that, it won't be a response in line with how public comment is received in person?
I will make, Commissioner Haas, I'll make a motion that we have a generic reply to incoming mail or written response that thanks the person for their time, effort, and input, and then directs them if they have further clarification or want to make additional to address at public comment time. That was a really broken up way of saying that. Sorry.
Second, Commissioner Jay.
Okay, Commissioner Haas, can I ask you just a clarification on your motion? Would your motion include identification of who would make that? Do you want to include in your motion that would be a member of the executive committee, for example?
No, what I'd like to do is make it through our mailbox with an auto response if we can, and then we can set up a rule that will forward it to all of us. But we can work with IT on that.
Okay, well, we can make the motion contingent upon working that with IT. It's been seconded by Commissioner Jay. Is there any opposed? Commissioner Klein.
So just to clarify, we've got the commission as a whole general email, and then each one of us has an email. Is the proposal, is the motion for all of our respective emails plus the commission's email going to have the auto response acknowledging receipt?
No. Just for the commission's email.
So then the person who has copied every single one of us on their message, this is what I was talking about, the multiple responses and acknowledgements from the commissioners that their message has been received. If we all adopt this acknowledgement policy or procedure, that would seem extreme unless we set up our own rules of acknowledging, do an email acknowledgement.
My motion's just for the general council or commission's email box. If you want to respond to constituents that directly email you, I think that's on each commissioner and what they want to do. But for the general public comment, written public comment coming in through the general email box is what my motion was for.
So commissioners, we're fortunate to have some IT representation in the room. The email that is intended to go to all of us without having to copy our individual emails does have the capability of being able to have an auto response. So if that influences the motion or the discussion, that would be the simplest. If we need the motion to include some type of response when the public member of the public contacts us individually with each of our individual emails, then some work would need to happen with IT. Commissioner Adebami.
Chair, I believe our bylaws state that we select a member of the commission. The chair represents the commission, so I think it would make sense that the chair be the one to respond if they were to email all 15 of us, and that we should not try to overwhelm them with our thank you acknowledgements from all of us individually.
Yep. Okay. Was there a comment over here?
This is Commissioner Landisberg. My comment was I didn't think we should have to respond to any particular email received from the public, especially if they're just going to send stuff that has no relationship to what we're really doing.
Okay. So I stepped away from the discussion just to confirm our IT capabilities, but would it be fair for the motion to restate the motion in a way that we have an auto response when emails are sent to the commission-wide email, and that auto response not be extended to emails that come to each of us individually? I think that's what we're saying. And Mr. Haas, is that consistent with your motion?
That is.
Okay. And Commissioner Jay, you made the second. You're fine with that. Okay. Thank you for that discussion and clarification. Commissioners, are there any objections to the motion as we've discussed it? Okay. Seeing none, then we will work with IT for the commission-wide email to be set up to send an acknowledgement to the sender. And when going forward, when each member of the body collectively receives the same email, then until we decide otherwise, the chair will respond acknowledging. Thank you. Commissioners, my clock shows 6:05. I'd like to propose and entertain a motion for a 5-minute break.
So moved.
Is there any opposed to a 5-minute break? Okay, seeing none, we will take a 5-minute break. We will come back here at 6:11 p.m. Thank you, Commissioners. Commissioners, it is 6:11. So if we could please find your seats and we'll resume. Thank you, Commissioners. Our next business item is item B under old business, meeting ground rules. For Rebecca, if you could please put that up on the screen while we discuss. So Commissioners, thus far, we haven't been operating under any formal meeting ground rules, but going forward, we thought it would be appropriate to have some. What you're seeing up on the screen right now is a set of proposed meeting ground rules. They're based in part upon similar ground rules that are adopted by the last Charter Review Commission with a few revisions. And what we'd like to do is present this to the body for discussion and potential adoption. Any comments or discussions? Commissioner Donnelly.
Oh, thank you. I have read through them and I think that they're excellent. And I would be willing to make a motion that we adopt them.
Okay, thank you. Before we go to the motion, we'll ask if there are any other comments, just kind of flesh out consensus or lack thereof. Any other questions or topics that would like to be discussed before we go to a motion? Commissioner Holmgren.
On part 9 for the remote meetings, I, just because this was likely going to happen this week, that I thought I was going to miss the beginning of the meeting, I would have been on the phone, not available for camera because I would have been driving here. I don't know if this precludes participation in that situation by the ground rules where I should just not call in if I'm on the way here and driving from a previous appointment.
That's a good question. And first of all, I want to thank you for your efforts to have participated if you found yourself in that situation today or going forward. That is a holdover. That language is a holdover from the last commission who met it during COVID. The majority of their meetings were remote. I think it is preferred, but could be perhaps amended to say preferred but not required or something along those lines, using your example. Commissioner Landsberg.
I would agree. It would be preferred than not required because as you all see, I often get up and stand and move around just because of my back problems. And so to say that my face needs to be on the camera while I'm moving around, I just think it should be preferred, but not.
Thank you. Okay. Any other questions or comments, proposed revisions? Okay. Would someone like to make a motion to adopt the meeting ground rules as shown, but with the amendment to number 9, saying that commissioners are, it is preferred that commissioners be present on camera. Commissioner Donnelly?
So moved.
Commissioner Adequame?
Chair, sorry, I just wanted to discuss number 9 a bit there again.
Okay.
Can we expect them to be present as in engaged, but prefer that they be on camera? So I think there's an ask there that they just maintain that engagement and participation, but don't necessarily need to be on camera.
Okay. Are you suggesting revised language, or would you like to suggest your revised language?
Yes, Chair, thank you. When participating remotely, commissioners are expected to be present and remain muted when not speaking. It is preferred that they be on camera.
Does that, Commissioner Donnelly, are you comfortable with that language as well?
Yes, I am.
Okay, and would you like to revise your motion to incorporate that?
Yes, I would.
Okay, is there a second?
Commissioner Jay, second.
Okay, thank you. Are there any opposed? Okay, seeing none, then we have adopted those ground rules as amended. Thank you, commissioners. We will now move back into first readings. Commissioners, in our last meeting, we did have a motion to table a vote on Amendment 26-03, which was a topic of discussion in this meeting. The members of the executive committee have discussed, and we would like to propose that that remain tabled, that not be brought forward for a vote, so that any dialogue or discussion on that topic has one more week to materialize before we come back and take a vote on that. So unless there's any opposition to that, then we will bring that back in a future meeting, and we will move forward with other first readings that have yet to be presented. Commissioner Chrisley.
Thank you, Mr. Chair. Just in regards to 2603, would there be any harm or objection just to tabling that until May and after filing week? And then people can make their decision from there, as opposed to having to preemptively say, as Commissioner Klein said, you know, somebody may be running, may not be running, but they're going to recuse themselves in March, and maybe they don't run in, maybe they don't file in May. But just a thought.
Well, that is the type of discussion that is prompting us to suggest that we wait another week. Okay, so then seeing no other objections, then we will continue to table a vote on 2603. Where we left off, then the next one would be 2606. And commissioners, what we'll do then is we won't necessarily go in strict numerical order. What we'll do is we will move according to sponsors so that multiple sponsors have an opportunity for their amendments to be read. We'll keep track of where we are. Eventually, all amendments, of course, will get their first reading. But if we go in sequential order, then because of the way that they're organized, there will be a concentration of sponsorship in today's meeting like we had initially last week. So with that, we will begin with the reading of Amendment 26-06. Primary sponsor, Commissioner Garber. Co-sponsor, Commissioner Hamlick. Title: Change Charter Review Commission election from 5 years to 10 years. Description of proposed amendment. Changes Article 9, Section 9.1, subsection A, Charter Review Commission. This proposal changes the first sentence in subsection A to read, every 10 years, the council shall cause an election of a Charter Review Commission. Purpose of policy intent of proposed amendment. 5 years ago, the first Charter Review Commission undertook a significant responsibility, recommending new amendments and clarifying existing sections of the charter for voter consideration with a 1-year timeframe. One of the proposed amendments brought forward to the voters was an amendment that future commissions be elected every 5 years, with commissioners elected serving a 2-year term. This amendment was passed by voters. The elected freeholders intentionally wrote our charter in a straightforward manner to ensure its passage. The initial commission's role was to expand upon the charter and make clarifying adjustments to this very minimal charter. Our home rule charter should be written broad enough that adjustments are not required every 5 years. A 2-year term provides the commission with sufficient time to evaluate all suggested amendments submitted by commissioners and obtain essential input from citizens. There is only one other home rule charter county in Washington that elects its Charter Review Commission every 5 years. Notably, we are the sole home rule charter county that elects commissioners for a 2-year term. Affected charter section, section 9, charter review and amendment, section 9.1A, charter review commission. Commissioners, before we open it up to clarifying questions, I'll remind you, everyone has the opportunity to ask one factual-based clarifying question. I would also clarify that before you ask your question, the question should be aimed at guiding your decision in your vote, and that details, debate-related topics are more appropriate for the second reading. So the question should be aimed at helping you decide whether you will vote yes or no on the amendment. Commissioner Jay.
Thank you, Chair. My question related to this document, I'm very much in support of it, but I was just curious if this could be something that we would be able to put on the 2028 ballot, as opposed to the 2026 ballot, or if that's something that we can make an inquiry on or decision on. Maybe not, obviously not today, but.
To answer. I don't have a concern if it goes on the last election for proposed charter amendments, as long as it happens before we are electing them again. Yeah.
Commissioner Selman.
As a matter of principle, I don't think we should be voting on things that the last Charter Review Commission proposed and the voters approved. This one, the voters approved, changing it to 5 years, just.
Commissioner Selman, I'll remind you to make your comment, clarifying questions. That feels like a debate or a advocacy.
Well, it's a question of whether we should consider this as a group or not. My answer is no, we shouldn't, because the voters just approved the change to 5 years, less than 5 years ago, by 2/3.
So the intent of
I don't think we should change that.
The intent of our opportunity to ask questions is to clarify factual content. Commissioner Adegwame.
Thank you, Chair. My question is related to the last two sentences under purpose and policy intent of proposed amendment. So is my understanding correct that all the other home rule counties are on a 10-year cycle, and that they are all, including the one, including the only other one that's in a 5-year cycle, that they all are in a 1-year term?
No, that's not entirely correct. Whatcom every year, every 10 years, 1-year term. Snohomish every 10 years, 1-year term. Pierce is every 10 years with a 6-month term. King County, they are appointed, and I believe it's 1-year term. I struggle to find their term in that. Clallam is the only other county that does it every 5 years. And it's a 1-year term. And then San Juan is every 10 years with a 1-year term. So.
Thank you. That's very helpful.
And I do, may I add one more statement?
Briefly.
Okay. I did find out the cost of our last commissioner election, that our races for charter review are the only things on the ballot. So it's the only thing Clark County is charged for. So the cost of the election plus voters pamphlet cost for this last election was $523,000, $840.23.
Thank you. Commissioner Holmgren.
This is something that's just, did we consider, or were other lengths considered beyond just 5 and 10 years?
When I was looking at this, no, I thought that that a 1-year term would be, I mean, a 2-year term, which would still give us plenty of time to conduct our business, but every 10 years would allow, I mean, the charter should be written broad enough that we should not have to be changing it.
Commissioner Garber, I'm going to ask you to limit your answers to factual and not advocacy.
You bet.
Okay. Are there any other clarifying questions? Anyone who has not yet asked a question?
Okay.
Commissioner Holmgren, you've already asked a question. You already had your opportunity. Thank you. Okay. If no one else has a clarifying question, then we will take this to a vote. 26, Amendment Proposal 26-06 as read. If you are in favor of having this amendment advanced to and qualify for a second reading, please raise your hand. I count 8. 1, 2. I'm sorry, put your hands back up, folks, please. Okay. Let me know when you're ready, Rebecca. Okay, 8 votes. It does qualify for a second reading. Sequentially, the next amendment is 26-07, which we have already entertained. The next one that we have not discussed and that has a different sponsor is 26-08. The chair is listed as a co-sponsor on this, so our vice chair will do the reading.
All right, 2608, the primary sponsor is Commissioner Jay. Co-sponsors are Donnelly, Benton, Klein, Silliman, Erickson. Proposed overview. Title is requires supermajority council approval for county taxes. Requires a supermajority vote of the County Council of Clark County, Washington to enact any new county tax or to increase the tax rate or tax base of existing county taxes, including property and sales tax. At least 4 of the 5 council members must approve such measures. The amendment does not change the county's taxing authority under the state law and would take effect on January 1 following voter approval. The intent is to require a broader agreement before the County of Clark County, Washington, can impose new taxes or raise existing ones, including property and sales tax. It reflects a policy preference for limiting tax increases in an effort to help control the overall cost of living. Affected sections are section 2.4. Having read and understand, are there any clarifying questions? Mr. Christian.
Thank you, Mr. Vice Chair. Yeah, my question is, has county prosecutor's office evaluated this to see if a supermajority would supersede and be preemptive to the Constitution, given that the Constitution of the state requires or it assumes a simple majority? So I think it would need to be sussed out by a county attorney.
I believe a similar 4/5 or higher supermajority threshold is already in place in Pierce County, as well as other counties as well in jurisdiction.
Commissioner Garber.
Thank you. Would there be an emergency provision, like in times of crisis, that would allow the council to bypass that supermajority?
I think I would be open to having that conversation, depending on how we define emergencies and.
Thank you.
Further comments or clarification? Yes.
Why 80%? That's a huge supermajority. That's outside the range of a normal supermajority, which is usually between 60 and 75%.
A high percentage given the limited amount of counselors. I can't divide them into 2 counselors themselves, so I'm adding 1 counselor as it is currently stated in the current review. And if we do enlarge it, I think that should also be built into the provision, say, assuming that we did increase the council to 7, I think we could figure out a new threshold then.
Commissioner Landsberg.
Well, how would you be able to figure out a new threshold if we're doing a charter amendment now and the redistricting committee meets in like 10 years?
We can future-proof it by building in different number totals. Say if we had 7, I could put a provision in a line that says 5 of 7. If we have, assuming we don't have 8, it'd be weird to get an even number, but we can move up from there as is reasonable to future-proof this amendment a bit.
Any further clarifying questions? Not seeing any, we'll call for a vote. Those in favor, please hold your hands high and keep them up until it's finished counting. Heard 7. We only need 5, so we'll move on to second reading. Thank you.
Thank you. Thank you, Vice Chair. Okay, we will pass over 26-09 because it's sponsored again by Commissioner Jay. We'll move to Amendment 26-10. Primary sponsors, Commissioner Silliman. Co-sponsors are Commissioners Klein, Benton, and Jay. Yep.
Just going to bring that up. There's a clerical error there, appears.
We are on 10, and we do plan to address that. We do have, and it's been acknowledged to staff that we have a clerical error, that there are two 26-11s. And we will reassign one of them to be 26-12. But for now, we are on 26-10.
Can you read the title of it, please? Because I don't show 2610 on my book.
Yes. 1% levy limit?
Yeah.
Nope.
Is that the one you want?
Nope. It got missed. It got missed on some of these. Or it's out of order. Way out of order.
Okay, we will come back to what is 26-10 while we work out the clerical matter, but we will move on to, there are two amendments that were assigned 26-11, one of which is titled 1% levy limit.
I think one might be actually 12 instead of 11.
Correct. And there's a second 26-11, which is titled prioritize public safety. I'm going to ask staff to reassign the amendment proposal that is titled prioritize public safety from 26-11 to 26-12. And for today's purposes, we will address 26-11.
Okay.
Title 1% levy limit.
Okay.
We will come back after we resolve the question on 26-10 in the future meeting. So for today, 26-11. Primary sponsor, Commissioner Silliman. Co-sponsors, Commissioners Klein, Benton, and Jay. Title 1% levy limit. Brief description of proposed amendment. Creates a 1% annual levy limit. Purpose and policy intent. Limits county annual levy increase to 1% plus new construction without a vote of the people. Charter sections affected, undetermined. Are there any clarifying questions that commissioners have? Commissioner Gasquet.
Is this meant to differ from existing state law or just to put the existing state law into our charter?
This is to put the 1% limit that exists now in the state levy limit into our county charter because the last 2 years, the state legislature has discussed doing away with that 1% levy limit. So it basically is the same levy limit that exists right now.
Commissioner Chrisley.
Thank you, Mr. Chair. So with that said, I think the other question would be what happens when they change state law? Obviously, it's preemptive, so now it's just the amendment's no good at that point. So we're going to bake something in there that moves along with state law as it changes.
Is that a question or a statement?
Okay,
so I'll ask again, just a friendly reminder. The purpose now is to ask for clarifying questions if you're unclear about the intent. So did you, Commissioner Silliman, did you have a quick response to?
I just disagree with the opinion is that if state law changes and you have a 3% limit now, according to state law, would that change this? I don't believe it would. I think we can exceed the requirements of state law. We can't be more lenient than what state law is. So like we couldn't enact in our charter now a 3% limit because it would be more than what state law allows. So we can't exceed what the state law, or we can't do less than what state law requires, but we can do more.
Any other clarifying questions? Okay, seeing none, we'll take this to a vote. If you are in favor of Amendment Proposal 26-11, as discussed, advancing qualifying for a second reading, please raise your hand.
I see 7.
I count 7 as well. Okay, 26-11 advances. What was reassigned is 26-12. We will defer to a future meeting. Same with 26-13, 26-14. Because same sponsor, we want to have some variety and give every commissioner an opportunity to have their proposals heard early. And, 26-15 was also read last time. So we will move to 26-16. 26-16, which is up on our screen now. Thank you. Okay, 26-16, primary sponsor, Commissioner Hamlick. Title, Amendment to authorize county council, removal of appointed counselors from boards / commissions and direction of votes by simple majority. Brief description of proposed amendment. Amend the Clark County Home Rule Charter to explicitly grant the county council the authority by a simple majority vote to 1, remove any counselor from a council appointed position on a board and or commission, and 2, direct an individual counselor appointed to such a board and or commission on how to vote on specific policy items or matters. Purpose and policy intent of proposed amendment. To clarify and strengthen the county council's oversight and the collective authority over its appointed representatives on external boards and commissions. This ensures that counselors serving in these roles act in alignment with the majority will of the full council, promoting unified representation of county policy, accountability to the elected legislative body, and efficient governance. It addresses potential conflicts where individual counselors may vote contrary to council consensus while maintaining the council's appointment power under executive charter language. This change enhances coordination without infringing on core separation of powers, Article 1.5, and aligns the council's legislative role in representing the county as a whole. Charter sections affected. Primary Article 2, legislative branch, specifically by amending or adding to Section 2.2, organization to include new subsections on removal and vote direction, such as new Section 2.2E, the council may, by simple majority vote, remove any counselor from service on a board or commission to which the council has appointed them. And new Section 2.2F, quote, the council may, by simple majority vote, direct an individual counselor appointed to a board or commission on how to vote on specific policy item matters, end quote, potentially cross-reference or amend related sections in Article 2 if needed for consistency. Commissioners, are there any clarifying questions that you'd like to ask? Commissioner Landsberg.
Well, my proposed amendment is very similar to Kim's, and I think we should combine them. When I looked at it as a different section, 2.4. So in some ways, I'd like to either withdraw mine or just be able to come back next time and get them together.
Commissioner, that is a great question. And you'll note that on our agenda, we have an agenda item today to discuss what's called tasks to our subcommittee, where we will be able to identify questions of that nature that we would like our subcommittee to undertake and bring back recommendations for this body. Commissioner Donnelly.
Thank you. I would like to just inform Commissioner Landsberg and Kim Hamlick that I would like to be part of the discussion because I have several important things that I would like to add to this. So maybe it's some additional input.
Are you asking to become a co-sponsor?
Um,
Commissioner Hamlick, are you interested in co-sponsors?
Of course.
Yeah, yes.
in its current form, I would not be a co-sponsor.
Okay.
Yes.
Okay, we'll come back. We'll wait for the vote, and then Commissioner Hamlick will come back and see if there's anyone who would like to be a co-sponsor. Commissioner Klein, do you have any clarifying question?
I do. Commissioner Hamlick, what is the motivation behind this proposal?
Well, really, this is, what I took this from was what they put in, the council right now put in their policy and procedures. But from what Councilor Brandt said before, when we spoke about it before, this being in their policy and procedures is what they're trying to add. I think it's just clarification. So we don't have the issues like we've had in the past here. I think it's cost us a lot of money, a lot of time of discussion. So I'm just clarifying things. So.
Any other clarifying questions? Commissioner Adequame.
Chair, I would just like to express my interest in being co-sponsor.
Okay, we'll come back to that after the vote if it passes. Any other clarifying questions? Okay, seeing none, if you are in favor of amendment proposal 26-16 being advancing for consideration in the second reading, please raise your hand.
Count 9.
Thank you. Okay, it advances. Okay, we'll come back. Now that it's qualified for a second reading, I'll ask for Commissioner Hamlick has indicated that she's interested in having co-sponsors. Commissioner Adequame has indicated he'd like to be a co-sponsor. Is anyone else who's interested in being a co-sponsor? Commissioner Gasquet, Commissioner Landisberg.
And can I withdraw my,
You could, yes, if you'd like to formally withdraw.
well, for the moment, I'd like to formally withdraw mine, at least for consideration and
Okay.
until.
We'll consider, and I believe to be precise, you were referring to 26-17.
Yes.
Okay. So commissioners, we will consider 26-17 to be withdrawn.
And if we're going to do this next one that I recommended, can I just add something to it that I didn't have a chance to do when we were?
We'll come back to that.
Okay.
Commissioner Landsberg, can you clarify which number you're talking about?
So on
26-18?
On 26-18, you asked us last time to indicate when we wanted to bring it forward. And I just wanted to say that my proposal would be not to consider it this year at all and
Okay.
to consider it next year.
Okay, so we will consider 26-18 to be temporarily withdrawn then. We can come back and discuss when it would be reintroduced. Okay, commissioners, we have time probably for one more first reading. And we will go to amendment proposal 26-19. Primary sponsor is Commissioner Landisberg. Co-sponsor is Commissioner Holmgren. Title, Amend Redistricting Committee Process. Brief description of a proposed amendment. Set date for persons to apply to serve on redistricting committee. For county council to make their selection to the redistricting committee date to meet to select its chair. Purpose and policy intent of proposed amendment. To improve timeliness of redistricting process and make it more transparent. Affected charter sections, section 6.5, redistricting committee.
So can I just ask Ms.
Commissioners, are there any clarifying questions? Mr. J.
I'm just curious how this would ensure the independence of the redistricting committee, given that the county council would go on to appoint. At that point, why not just draw their own lines?
Commissioner Lansberg, would you like to answer that question?
Because right now, there's no way for people, in the past, the parties nominated. And right now, that's not happening the way the amendment was passed by the folks. What I'm trying to say is that anybody would have a chance to apply by, let's just say, November 15th of the year before the census comes out. And that there would be more specific dates to get county council doing their business. What happened last time is there was such a lag time that, nobody knew what district they were going to be in until the last minute. And if you move up the process, if there's any litigation to be had, it just creates that things get done before people need to run.
Thank you. Any other clarifying questions? Commissioner Klein.
What constitutes the convening of the redistricting committee? Is there a current redistricting committee right now, or is it, when does that become a convened committee?
It involves the census. So it's going to do its business right after the census. And so the question is, do we want to get the committee in place so that when the census data comes, they can immediately do what they did last time? The census data was late because of COVID, which made it even more problematic. So it's statutorily not going to come in to effect. So you're not going to have a redistricting committee next year or the following year or whatever. It's only for when the census comes.
So one secondary question to clarify.
Quickly.
So then you are wanting to change the current process, which is for appointments by parties.
No, that was taken out.
Was it? Okay.
That was taken out. I would have preferred that, but that was taken out.
Okay, any final clarifying questions on this topic? Okay, seeing none, if you're in favor of amendment proposal 26-19, advancing qualifying for a second reading, please raise your hand.
Count 8.
I thought I had more time. Please put your hands back up, commissioners.
8.
Count 9.
Oh, I'm sorry. 9.
9. Thank you. Okay, commissioners, we will pause on first readings in this meeting, and we will pivot into our next agenda topic, which will be an opportunity to quickly provide guidance to the subcommittee, the work plan subcommittee, which will be meeting tomorrow. And what we'd like to do is just a rapid fire roundtable. If you have a specific question or topic that you would like the subcommittee to address, now's your chance to quickly mention that. Commissioner LeBrant.
Yeah, I actually just have a question for the group as we go around that would help me as a member of that.
You speak into your microphone a little bit closer, please.
About that. I do have a question that I'm hoping some folks here can weigh in on, that'll, I think, help us on that subcommittee. And this is very general, but to think about what success for this group means for you, whether that's, you get something on the ballot the way that you want, but it fails, but maybe that's worth something or a value to you. Getting something on the ballot and maybe a little less like you'd prefer, but it passes with the voters, because I think that can shape how the plan gets put together and what sort of process we follow. So give that some thought, and that would, I think, help us.
Okay, thank you. Commissioner Holmgren, do you have any quick comments or questions that you would like the subcommittee to address? Examples would be like what was just brought up, the process for merging two intake forms.
I would like some clarity on what we think the assignment to committee process will look like once we get past second readings. To me, that's still a little fuzzy.
Okay, thank you. Commissioner Klein.
I think a visual flow chart, once we have the settled process, would be a good tool for you to present to the commission when you come back to us.
Okay. And thank you. And for clarification, the subcommittee will be bringing ideas, information, proposals back for this body to deliberate upon. Subcommittee won't be making any final decisions. Commissioner Jay.
I think we'll need cutoff dates for different ballots and as well as clarification of which ballot goes or which amendments goes on which ballot, as well as clarification on resubmitting different amendment proposals or sending things backwards in the process.
Okay. Yep. And to that topic real quickly. So we are going to be discussing the amendment process, amendment deliberation, as well as timelines. So to the commissioners, we've yet to establish what that timeline is, but the time will come. I expect that the window will close for intake forms to be received. So if you are contemplating a submission of an intake form, I encourage you to do it sooner rather than later. Commissioner Benton.
I'll just express my gratitude for the members who are part of that committee.
Thank you. Commissioner Sullivan.
Nothing, sir.
Commissioner Garber.
Nothing at this time.
Okay. Commissioner Haas.
I have nothing.
Commissioner Chrisley. Nothing. Commissioner Landsberg, anything else you'd like to add?
I would like perhaps to look at the cost for the amendments so that is it more advantageous to try to push like 10 amendments that we may have? Would it be advantageous, like on the one that I want to defer, not to do it in an off-year election, which is next year, but to defer it to the following year when it has huge turnout? And so I was wondering if we wanted to be looking at strategy as to when is the best time to do some of
I
these.
can offer a little bit of feedback on that because I asked Audra Kinsey about cost because that topic has come up in a prior meeting. I asked him and he appropriately indicated that there's a lot of variables that go into assigning the cost to a specific amendment, charter amendment on the ballot, takes into consideration other races, other matters that are on the ballot. And so specifically for the November 26th ballot, I asked what would be the cost for 3 charter amendments, what would be the cost for 7 charter amendments. And the average in both cases is between $15,000 and $20,000 per amendment. So for example, he said approximately $110,000 total to the cost to the county should we put 7 amendments on the ballot. That number would likely change in future ballots because the variables that went into that determination would change. Commissioner Hamlick, do you have any input on tasks for the subcommittee?
No.
Okay. Commissioner Gasquet.
Recess after we submit stuff for the ballot.
Yep, I think you're not alone in that. Yep. Commissioner Donnelly.
No, nothing right now.
Okay, thank you. Commissioner Adequate. Yes.
Thank you, Chair. Just a couple of things. One, I want to echo a bit of Commissioner Klein's comments, and then I think it was maybe last meeting that Vice Chair Haas said, no good plan survives first contact, something to that effect. So I really would invite the committee to think of this in an operational manner. We've seen that we approve a step and then the next meeting, we kind of immediately have questions as to what we're meant to be doing, right? And so think about it from the workflow standpoint of when someone is going through these steps that we're outlining, what questions might they have, and try and get that FAQ sort of ready ahead of time. Beyond that, I want to echo Commissioner Benton's point and expressing admiration and gratitude for the committee and doing that work and advocate for that timeline and understanding of the windows for when each part of the process is meant to happen, both this year and in 27. So thank you, Chair.
Thank you. Commissioner Garber, you had another comment?
Yes, I did think of something. I think one thing that we need to also look at is the number of amendments that are placed on the ballot to think about, the actual real estate on the ballot and what else is going to be on there. So come up with a set number that we cannot exceed for each election.
Okay. Commissioner LeBrant, one more comment?
And to kind of piggyback on that a little bit, that's why if you can email someone on that committee before tomorrow about what your idea is of success, because I think don't email all of us because we don't want to set off a quorum, but let somebody know on that committee what you're going for if this group is successful in your mind. So because I think that speaks to that specific point about how we want to structure these things.
Yep. Thank you. So friendly reminder, there are 7 members of the subcommittee. And so we need to be very mindful about not having a serial meeting. So to Commissioner LeBrand's comment, if you do email a member of the subcommittee, just do it to the individual member, not to the committee as a whole. And I would ask then that you be very mindful and limit discussions or questions to the subcommittee to our next meeting, and encourage the members of the subcommittee not to discuss its work outside of the public meeting. It is a public meeting. You're welcome to attend, but you can't participate just as a member of the public would. So just please be mindful of that. And one last clarification, you may remember that the work plan has 3 components. It's the deliberation and adoption process, timelines, and public outreach. We'll first be tackling the deliberation and adoption process and timelines. We may not get to public outreach, but that will be coming soon. And when we get ready for that, we will go around and be soliciting input from the commission about what public outreach looks like and what this body would like that to include. Okay, thank you, commissioners. Our last agenda topic is good of the order. Is there anyone has a topic for good of the order? Commissioner Haas.
I have one. I'd like to see if we could save the county some money in future meetings coming up and cut the air conditioning down a little bit. We check with facilities maybe? Either that or we could bring meat in and hang it because it's cold in here.
A point of personal privilege, I believe.
Yes.
Okay, thank you. Any other topics for good of the order that anyone would like to bring up? Okay, commissioners, thank you for being here. Thank you for your time. Thank you for your dedication to this process. Is there a motion to adjourn?
Motion to adjourn. Klein.
Any opposed? Okay, thank you, commissioners. We are adjourned.